central to the Cliff dispute with Mnet was that he had a verbal contract with the broadcaster. Let's get a bit more detail on this issue now. I'm joined on the line by attorney Irene Rome. Irene, good morning to you, or good day to you rather. Thank you so much for your time. And this was a matter of concern for some in the legal fraternity. They felt it was going to be a real test of the verbal contract in court. Do the results surprise you?
I don't think the results surprise me. Verbal contracts are binding in law and always have been. They obviously are far more difficult to prove. In fact, Groucho Marx said oral contracts are not worth the paper they are written on. But in this case, clearly Marx was wrong. And a contract can be verbal or in writing, and there only are a few contracts in law that are required to be in writing, such as a contract for the sale of land, and that is by legislation that it is required to be in writing. What you have to do is prove the material terms of the contract, which are in law called the essentiale, and in this case, it would mean that Cliff would have had to prove the essential terms of his contract going forward with MTN.
What is interesting is that many companies tend to operate, certainly in the media industry, this way, where they develop a relationship with a particular artist. They use that artist regularly in terms of on-air work, but they don't put any of it in writing, and that person often continues on a long-term contract based on a verbal agreement. What lessons have we learned from this particular court case?
Well, I think that one of the things about contracts generally is you're better off to have them in writing, because if there's a dispute, that is what the parties can immediately rely on and say this is what was agreed upon. Otherwise, the parties have to individually prove their own case. And as you can see in this case, MTN and Gareth Cliff argued from very different positions as to what their rights were, or if there was a contract at all. And it's always very important to reduce things to writing if you can, but if it isn't, it doesn't mean you don't have a contract. And a lot of these contracts are based on trust between the parties, relationships between the parties, and those sorts of things.
Irene, just to clarify one thing, of course, we're talking about Mnet here and not MTN.
Yeah,
but
Mnet. I apologize for that.
Not at all. Okay, so what I do want to ask you about is this notion of establishing a convention that many companies may do, where they employ you over a particular time to fulfill a certain function. You're not given anything in writing to back that up. And in future, are you able to then go back and say, because you used me over a certain period of time for this, I can assume in future that this will continue to be the convention of our relationship. You will continue to employ me, and these will be the terms of that relationship, even though that person has not been formally appointed to a position. Does that have standing before a legal entity like the CCMA or a court, for example, if a company has used a person in that capacity over the long term?
I think the answer is quite a difficult answer. It would really depend on the circumstances, and I think a labour case would be quite different from an ordinary contractual case because of the different law that has developed in relation to in the labour arena, where a contract has rolled over and rolled over. There is law that supports the fact that the person has a reasonable expectation for the contract to continue, and it's in fact partially legislated. In a situation that Gareth Cliff is in, I think that would be much more difficult to prove. I think that there would have had to have been a commitment to go forward. You would have to prove that commitment to go forward. There would have to have been discussions about next season you will also be doing this, or in the following season you'll be doing that. You'd have to prove those kinds of elements. And I think that they would often be very difficult to prove verbally without it being reduced to writing.
Thanks for